here at the University of Houston. It's my honor and privilege to host today's Fireside Chat in conjunction with NASA's Johnson Space Center. You should have received a card when you arrived with a listed website of what's right up there on the screen. We've gone the electronic way, so no direct questions from the floor or on cards, but to really turn it in electronically at that website. You should be able to put that on and with your smartphone, and Michael Haggerty here will assemble those questions and ask those. Before we begin, I'd like to introduce today's moderators. Our audience moderator today is Michael Haggerty, senior producer for Houston Matters with the Houston Public Media. He has a degree in journalism from the Abilene Christian University and has served as news director for NPR and PBS stations around Texas and the West. I'd also like to introduce our two stage co-moderators, Dean Len Baines and Professor Sapna Kumar of the UH Law School. Len Baines serves as Dean and Professor of Law at the University of Houston. He brings a national reputation as a communications law scholar with specializations in business, media, and diversity issues. He oversees 10 centers and institutes, including the number 6 ranked Intellectual Property and Information Law Institute and the number 8 ranked Health Law and Policy Institute within his college. Dean Baines received his BS from New York University and JD and MBA from Columbia University. Baines was awarded the Earl Warren Scholarship and the Cogme Fellowship at Columbia, where he also served as associate editor of the Columbia Human Rights Law Review. After law school, Baines served as a law clerk to Federal District Court Judge Clifford Scott Green in the Eastern District of Pennsylvania. Professor Sapna Kumar is an associate professor of law at the University of Houston. She is an expert in the application of administrative law to patent law with an emphasis on the International Trade Commission. Professor Kumar received her JD at the University of Chicago, where she served as a staff member of the University of Chicago Law Review. From 2003 to 2006, she practiced intellectual property litigation in Chicago at Kirkland Ellis LLP and at Paris Hall McAuliffe. She then spent 2 years at Duke University's law school, where she was a faculty fellow and part of the Center for Genome Ethics, Law, and Policy. After completing her fellowship, Professor Kumar clerked for Honorable Judge Kenneth F. Ripple on the U.S. Court of Appeals for the Seventh Circuit. Before I introduce our honored guest here, I'd like to introduce my colleague, Richard Wilson, who will do the honors of introducing Michelle Lee. Richard is the Associate VP for Technology Transfer at the University of Houston, has an illustrious career as a chemical engineer here at the University of Houston, and he himself has a family background, which is rather remarkable, of a father who's an IP law practitioner and a son who's an IP law practitioner. So I don't know what he's doing in between being a professor, but with that, Richard.
Thank you. I should also note that Ramanan used to be my excellent and highly productive leader and boss in chemical engineering and is now my excellent and highly productive leader and boss in the Division of Research. So it's a great pleasure to welcome the head of the Patent Office, both personally and for the city and for the university. Houston is a great city for intellectual property. It's a great innovative center. It's a place where we have many engineers and technologists. My father always described it as a good city for patent law. The university is a very strong place for intellectual property. Obviously, we have the excellent IP law program here. We have an excellent entrepreneurship program, which starts companies around some of our intellectual property. And it's always a surprise to people when I point out that among American public universities without medical schools, the university is #1 in the United States for patent royalties. We have a really extraordinary faculty who produce very, very valuable intellectual property. Since those royalties come through my hands, through the hands of my office, I'm a very popular guy in the Division of Research. So it makes my job quite pleasant. And then as Ramanan mentioned, I'll note that I got exposed to intellectual property law very, very early. My father was on the board of the AIPLA and the LES, and my sister and I used to crawl around on the floor sorting the AIPLA economic survey, the salary survey, punched Hollerith cards, you know, the old computer cards. When I was very small, I think he paid us $0.05 an hour or something to do that. So my exposure to the intellectual property activities started very, very early. I ended up as a member of the National Academy of Inventors, and my father and I have done some stuff together, and my son James Wilson is here in town as a successful IP attorney as well. So we do have a great family history, which I won't dwell on further. So as you know, the U.S. Patent and Trademark Office is a leading force in American innovation policy. The agency reviews hundreds of thousands of patent applications every year and grants IP protection to those who are able to persuade the agency that they have a novel and useful idea. As a major force in U.S. innovation policy, the PTO works closely with Congress, the administration, the legal community, and industry to implement new approaches to innovation and patent filings. So today, I'm greatly honored to welcome Ms. Michelle Lee to the University of Houston. She is the Undersecretary of Commerce for Intellectual Property and the Director of the United States Patent and Trademark Office. In this position, she provides leadership and oversight to one of the largest IP offices in the world, with over 12,000 employees and an annual budget of over $3 billion. Ms. Lee also serves as the principal advisor to the President, through the Secretary of Commerce, on domestic and international intellectual property policy matters. Through working to strengthen the IP systems, including patents, trademarks, copyrights, and trade secrets, she helps promote innovation and economic growth for the United States. Ms. Lee also drives international intellectual property harmonization efforts, which support the administration's top priorities to increase both trade and economic growth. I'd like to highlight that Ms. Lee is the first woman to serve as director of the U.S. Patent and Trademark Office in the country's 225-plus year history. Prior to her current role, she served as deputy director. Prior to her current role, she served as deputy director, and before that as the first director of the USPTO's Silicon Valley regional office. Ms. Lee has spent most of her professional career advising some of the country's most innovative companies on technical, legal, and business matters. Prior to joining the USPTO, she was deputy general counsel for Google and the company's first head of patents and patent strategy. She joined the company when it was relatively young and was responsible for formulating and implementing its worldwide patent strategy, including building its patent portfolio from a small handful of patents to over 10,500 assets in 8 years. She also served as a partner at the Silicon Valley-based law firm of Fenwick & West, LLP, where she specialized in advising a wide range of high-technology clients, from startups to Fortune 100 companies, on technology licensing, intellectual property, litigation, and corporate matters. Prior to her career as a legal advisor to technology companies, Ms. Lee worked in the federal judiciary as a law clerk for the Honorable Vaughn R. Walker on the U.S. District Court for the Northern District of California, and the Honorable Paul R. Michel on the U.S. Court of Appeals for the Federal Circuit. Before building her legal career, Ms. Lee worked as a computer scientist at Hewlett-Packard Research Laboratories, as well as at the Massachusetts Institute of Technology, MIT, Artificial Intelligence Laboratory. She holds a BS and an MS in electrical engineering and computer science from MIT, as well as a JD from Stanford Law School. Ms. Lee has been recognized by numerous organizations for her work, including by Politico magazine as one of the, quote, top 50 most influential visionaries in American public policy in 2015, by Washingtonian magazine as a, quote, tech titan in 2015, and by the San Francisco Business Times and San Jose Business Journal as the best Bay Area IP lawyer in 2012, and one of the top 100 most influential women in Silicon Valley in 2013. At this time, it gives me very great pleasure to begin today's fireside chat by turning it over to Leonard and Salma.
Thank you. Good afternoon. I'm Leonard Baines, as Ramanan indicated. I'm the Dean of the Law Center, and my co-moderator is Sapna Kumar, and we will take turns asking Director Lee questions. I want to first welcome Director Lee here to Houston. She has been the director of the U.S. Patent Office for a little bit over a year. She was sworn in at South by Southwest about a year ago.
A year ago tomorrow.
A year ago tomorrow. So we're very proud that she's back in the great state of Texas and in the great city of Houston. And the audience is a great audience of people of very diverse backgrounds, some with a lot of knowledge of patent issues and some that have, varying interests in this. And so Director Lee, you are the top intellectual property figure in the nation, and some would say clearly in the world. And so patents are very important for innovation and driving innovation and economic growth in the United States. So what, in your view, is the role of the U.S. Patent Office in promoting this process of innovation?
Well, thank you very much for that question. And let me just say to my two moderators and the audience, thank you so much for having me here. It's a real privilege to be in Houston, and thanks to NASA and the University of Houston for organizing this incredible event. Intellectual property and its role in promoting American innovation, and the USPTO in particular. I like to refer to the U.S. Patent and Trademark Office as America's innovation agency. And our mission at the highest level is really as simple as promoting American innovation through intellectual property rights. And we do so many things, and we work with so many stakeholder groups to try to provide the incentives so that all of our great scientists, engineers, and researchers have the incentives and are willing to invest the energy to create amazing products and services, incredible inventions, life-saving drugs and so forth, and help them bring that to the marketplace by giving them an exclusionary protection on their invention so that they can recoup their investment. So really, at the highest level, whether we're examining patents for the invention, whether we're registering a trademark to protect a brand, whether we're talking to foreign offices across the globe or foreign governments across the globe about intellectual property policy, the goal is to incentivize American innovation and create a level playing field for American companies when they look to sell their products and services overseas.
Director Lee, could you take a few minutes to outline your priorities and agenda for the rest of the coming year, which will be the final year of the administration?
Yeah, so it is so my history with the USPTO, actually I like to say, although I moved to Washington 2 years ago, my interactions with the Patent Office go back all the way to the beginning because I've been practicing IP law my entire career, and of course, in helping all the Silicon Valley companies when I was in private practice and representing them, I used many services of the PTO. And then when I was at Google, helping build up portfolio from a handful of patents to 10,500, I used almost all the services of the United States Patent and Trademark Office. So I then became the regional head and then eventually the leadership role, but I've been a user of the Patent Office's services for a long time, and that, I would say, helps inform me in terms of my priorities because I've used the services as a customer from many different sides. I've written patent applications, I've asserted patents against others for infringement, I've defended against patent infringement, I've done a ton of licensing. I know there are a number of tech licensing folks here in the audience, both from universities, from my companies, and then I don't know if those of you who are following, there was the Nortel patent auction that sold for $4.3 or $4.5 billion, and I was representing my client in that transaction, so I clearly get the business value of intellectual property. And so with that, as I define my priorities as the director in the time that I have, I would say it's a couple fold. First, certainly, it's the timely issuance of high quality patents. And timely, I think we've done a pretty good job so far. I mean, those of you who've been practicing know that there was a certain time where our backlog was pretty high of newly filed patent applications. That was about January of 2009, that was the height of it. And it has come down by 26.6% since that time, despite a 3 to 4% year-over-year increase in filing. And our pendency is about now 16 months on average for a first office action and 26 months until final issuance. And our goal is to bring that down to 10 months for the first office action and 20 months until final issuance. So timeliness is important so that businesses and universities can conduct their business, make their investments, and have greater certainty in the intellectual property right that they're getting. But another piece of that is not just that the patents issue quickly out of the United States Patent and Trademark Office. They must also issue with a high degree of quality. And that has become increasingly important. I can go into much more into that point later on, but a major initiative of mine is to enhance the quality of the patents that the United States Patent and Trademark Office is issuing. Both issuing and also the quality of the patents that have already issued from the Patent and Trademark Office. And there are a number of post-patent grant review proceedings that allow us to double-check the validity of a patent that is already issued. So timely issuance of high-quality patents, number one. Number two is standing up and integrating 4 regional offices across the country for the first time in the PTO's history. I mean, the American Invents Act passed in 2011, and through that we got authorization to establish regional offices outside the DC area. So the Patent Office goes all the way back to the founding of our country. And believe it or not, for the most part, we just operated out of the Washington, D.C. area. And pursuant to the American Invents Act, we now have 4 regional offices in Detroit, Denver, Dallas, and Silicon Valley. And let me say that there's nothing but upside to these regional offices, and you all are fortunate enough to have one. I know not in your home city, I get that, but in your home state, and it's meant to service the entire south central, southeastern part of the United States. And I can go into more about what that means for all of you, but it really is bringing a broader range of the many services that the USPTO has to offer in support of the innovation community, and it's bringing it to you in your local neighborhood. So I would encourage you to definitely take advantage of it, and I can go into more of that later on. So timely issuance of high-quality patents, standing up our 4 regional offices and integrating them with the core mission of the United States Patent and Trademark Office, making sure, thirdly, that the post-grant review procedures that have been recently authorized pursuant to the American Invents Act operate as fairly and as efficiently as possible. And fourthly, I would say our international efforts. In this day and age, companies are becoming increasingly global, and you're not doing your company service if you're just thinking of the US market alone, especially when the internet allows, if you can sell your product or service over the internet, you can just as easily have your first sale in Beijing as in Austin or Houston or San Francisco. So you really need to be thinking international from day one, and what does that international landscape look like from an intellectual property perspective? And should not all these countries whose businesses are increasingly growing global be considering harmonization, in other words, uniformity of some of the substantive patent law issues, as well as procedural processes for filing and obtaining IP rights. So I spent a good amount of time on the 4th bucket, which is the international piece of it as well. So I would say those are some of the priorities. I mean, I could go on, many priorities, lots of things to work on, but those are some of the highlights, I think.
And it sounds like what I hear is a real strong focus on quality, patent quality. And that seems to be one of the hallmarks of your tenure. Can you give us a little sneak preview of other things that may be happening at the Patent Office?
Yeah, so on the quality front, I mean, you might be asking, okay, so what's new? I mean, surely you're not the first director of the United States Patent and Trademark Office to say that quality is important. And you're right, I'm not, nor will I be the last. Or I hope I won't be the last. But what's new and what's different? First of all, pursuant to the American Invents Act, we've had the ability now to set our own fees. And if you think about it, any business that produces a product or a service is able to decide what price they charge for the product or service they provide. It makes complete sense. Well, before the American Invents Act, we didn't have that authorization. We now do, so we set our own fees. And now we work with Congress so that we basically, in recent years, have been able to keep all our user-provided fees. We are not subsidized by taxpayer dollar. So in the past, some of our fees that we collected went to other parts of the government. So we are in a better financial situation now because we can set our own fees, and working with Congress, we're able to keep all the fees that we collect. And we price our services based upon what we think it costs to provide the service. So if we keep anything less than that which we collect, we're sort of making do with less. So our financial situation is better. And then thirdly, I would say that, I think many of you know this, you're reading the news, the patent landscape has changed considerably. And you read a lot about an increase in the number of entities or businesses who are established whose one and only purpose is to buy a patent, and sometimes preferring patents that are broader and vaguer so that they can assert it against wide or broad sections of the industry, and hoping that the defendant or the recipient of the demand letter doesn't look too hard and is just willing to pay a certain amount of money to make the litigation go away. And in that environment, I think it is incredibly incumbent upon the USPTO to issue patents accurately and clearly. And that's what I mean by enhanced quality, which is accuracy and clarity. And I think the PTO has done a pretty good job in the past, and especially recently, on the accuracy of its examination. I mean, when Supreme Court rulings get handed down, not often, but when they do, one of the first things we do is our patent examination quality team pores over the opinion, right? Our examiners are making decisions every day about is this not eligible or not, right, based upon the case law. So we give guidance to our examiners. And you all, too, need to know if the applications that you're filing are on a subject matter or are eligible for patent protection. So we're pretty good at, I think we've been doing a good job at issuing patents accurately. I think a lot more work can be done on the clarity of the boundaries of a patent. And in particular, in some technology areas where there's not a common terminology, and oftentimes parties spend huge amount of resources litigating the meaning of, the scope of the claims and what it means after the patent is issued, when businesses have already made decisions about what they are putting in their products and what designs they're doing. And at that point, when you're spending a lot of money after it's been baked into a product and that product is in the channel for distribution, it's very expensive to then find out that you're infringing a patent and to have to pull that product or that service away from the marketplace. So really, we want businesses and universities, all players in the innovation ecosystem to have the ability to look at the patent and determine with greater certainty and clarity what is within the scope of the patent and what is not. So one of the things I did is I established literally an entirely new department in the patents organization whose only one purpose is to focus on ways to increase the quality, both the accuracy and the clarity of the claims that issue out of the Patent and Trademark Office. So an entirely new department, the financial resources and the structure in place for this thing to continue for decades to come. And patent quality is not a quick fix. I mean, you just don't do a couple of initiatives and great, you got good quality patents. I mean, if it was that easy, we would have done it a long time ago. Any company that produces a top quality product has focused on it for years, if not decades. And that's really the goal here, which is to kind of build that structure in place and put an emphasis, and I think it's a somewhat new emphasis on the clarity of the patents. These patents will go out, they will have an intended use by businesses, and the businesses need to be able to make informed business decisions based upon this patent. And so we have a lot of training going on with our examiners. For those of you who are patent attorneys, right, you're going to know on 101 what is patent eligible subject matter, on 112F how definite and clear the patent claims have to be, and the written description, and a lot of training as well on putting clear statements in the record, like what is the claim construction and what are the reasons for allowance, so that litigants aren't spending years or a lot of money years down the road litigating what the patent examiner and the patent applicant probably had a meeting of the minds on. So we have about a dozen initiatives that we've launched. If you're interested in finding out more, and I could go on, but there are 12 of them to start with, I'd encourage you to go to the USPTO website and search under Enhanced Patent Quality Initiative, and you'll see some 12 initiatives, one involving clarity of the record, another involving, for example, feeding back results from our post-grant review proceedings back to our examination core so that we can improve the results coming out of the examination core. It's a feedback loop. But there are some 12 initiatives, and we're very excited about it. The public, we've gotten a lot of positive feedback on the quality initiative and the importance of focusing on quality now that we have the dependency going down, and it will continue to go down.
You've also mentioned the work of the Patent Trial and Appeals Board, which was created a few years ago under the America Invents Act and handles post-grant reviews of issued patents as well as appeals from the PTO. And in particular, inter partes review has proven to be incredibly popular with members of the public, giving them a way of challenging weak patents that previously they didn't have. So I would love to hear your thoughts on the Patent Trial and Appeals Board and what your thoughts are in terms of how it improves intellectual property rights.
Great. Well, so for those of you who are not familiar with the inter partes review process or any of the number of post-patent grant review processes that allow the public to bring a patent that has already issued back to the office. I mean, there are about 3 proceedings that were created pursuant to the American Invents Act, which passed in 2011, that allow the public to bring a patent that is already issued back to the PTO to take a second look. And the thought behind that is that by bringing it back to the Patent and Trademark Office, you get a panel of 3 technically trained judges to adjudicate the validity of the patent. And pursuant to the statute, you have to make these determinations within 1 year of the start of the proceeding. And for those of you who have been involved in district court litigation involving patent cases, you don't get much within 1 year. And it's certainly, through our proceeding, it's lower cost because there's more limited discovery. So these proceedings, I think Congress intended very much that these proceedings provide a mechanism to remove patents that had already issued from the Patent Office, Trademark Office that should not have issued in a faster, lower cost manner. And we've had more than 3 times the number of filings that we originally anticipated. So right now, to date, we've had some 4,300 petitions filed in our AIA trials. And if you base popularity on the number of filings, I guess you would say they're pretty popular. I do think there's a lot of sense to these proceedings, and that's because, I mean, I was head of a patent department for a major corporation, and I know there are a couple of heads of patent departments in major corporations here and small corporations as well. And sometimes you know which ones are your crown jewel inventions, and you spend a lot of time working on them, and you're making sure that they're really rock solid and airtight. And oftentimes you don't, and maybe in the university setting, the research is so early, and it's hard to tell which of your many great inventions that you've got is going to be the one. And so with the AIA proceedings, right, you file for your, well, at the Patent and Trademark Office, you file your application, and the idea is with these post-grant review proceedings, after the market has had time to define and determine which intellectual property rights, which patent rights are of greatest economic value to society, and if at that point people say, wait a second, I don't think that patent should have issued, then you can bring it back to the Patent and Trademark Office and have, again, a panel of 3 technically trained judges look at it. They know all the presumptions that were applied at the Patent and Trademark Office, and they can take another look and determine whether or not it should have issued. So I think there's some logic to that. All of that said, we've now had these proceedings for 3 going on 4 years. The filings have been very high. We're running to stay ahead. And we've been able to stay ahead. We've been able to meet every one of the very strict 1-year statutory deadlines. And the Federal Circuit, which is our reviewing court, has so far affirmed almost all of our decisions. And the feedback that I'm hearing from the stakeholders are that the opinions that are issued are pretty well reasoned and quite detailed in terms of the analysis. Now, the challenge is to continue to maintain that as the board continues to grow. And also, as I look forward, I mentioned the PTAB proceedings as one of my priorities. We need to make sure that those proceedings are as effective and fair to all parties as possible. And we implemented the procedures pursuant to broad statutory guidance, which is what you get from Congress, and there were some judgment calls along the way, and we are entirely open to, and we went through extensive public input and comments on various additional refinements on these proceedings, and we'll be putting forth some refinements to the proposed procedures and rules for the PTAB proceedings going forward, and we're willing to iterate as many times as possible because a lot of people are using these proceedings, and we have to make sure that they are both effective and fair procedurally and process-wise and so forth, and we're committed to doing that, provided it's within our congressional mandate and the statute.
Thank you. As you acknowledge, universities play a major role in creating innovation. How does intellectual property and the work of your office facilitate what universities are doing?
So universities are one of our most prolific inventors and filers. I don't know, I read a statistic that said something like more than, you probably know the answer to this, but I think more than 50% of the basic research comes out of the university setting. That's remarkable. And that means our universities are a tremendous resource and a driver for our nation's innovation economy. I mean, without the universities, I mean, we don't get a lot of that very, very basic foundational research. So, and then I know it's something like 20% of the applied research too comes out of universities. So it's not just the basic research, it's the applied research as well. So I guess I come out of a region from the Silicon Valley where I think a lot of the economic growth, if you really trace it back, much of it came from the universities, the research labs there, the students in the research labs then taking an idea that they had worked on in the university. I mean, Google was founded on the PageRank patent that Larry Page worked on when he was a PhD student at Stanford, that then Google, through the Office of Technology Licensing, licensed it back out to Google, and it formed the basis and the foundation of the company. And ultimately, there were many technologies that contributed to the success of that company, but that was a pretty core piece of technology that emanated out of university research and through the technology licensing office at the university. So I would say universities play a very critical role in our innovation ecosystem and economy, and it's incredibly important that the U.S. Patent and Trademark Office and our entire system continues to operate in a manner so that we continue to promote this great research that goes on, and importantly, help it to continue to commercialize. I know we have some tech transfer folks in the audience here, but really to provide you the opportunity to commercialize it. And you're not going to commercialize it unless you have the intellectual property protection that you can then license. I spent a good part of my career doing licensing deals, and you do need the intellectual property right in order to license. So that's how the USPTO comes into play, is we provide that intellectual property right, whether it be a patent or a trademark or another form, so that companies and universities can license that and generate revenue and then provide and fund additional research.
Startups have been steadily gaining prominence in our economy and here in Texas as well. You having come from Silicon Valley, having started at Google when it was just a tiny little company, I know that you have this interest in startups and startup culture. What is the PTO doing to help startups?
So after after my visit to Houston, I will be on my way to South by Southwest, where there are a lot of startup companies, and supporting the startups and startup activity is really a priority for the administration and the USPTO, because if you look at it, small businesses and startups have an outsized impact on job growth and economic opportunities in our country. And the future of innovation will likely come from a company that we don't know about today. If you look at the past, right, oftentimes some of the most revolutionary inventions don't come from the most well-established players. They come from an outsider. So supporting the small companies, supporting the individual inventors, making sure that they understand that once they come up with some incredible invention, that they have the tools of intellectual property to help protect it, so that as they commercialize it, they can have the ability to recoup their inventions, is tremendously important. So we launched a startup initiative last year. When I go to South by Southwest, we are going to have a partnership meeting where we're going to be talking to a lot of the startups at South by, sharing with them the wide range of resources we have for startups. It's things like, I mean, many of the companies know, what are the basics of filing a patent, registering a trademark? How will these tools help me achieve my business goals, or might help me achieve my business goals? What intellectual property assets do I have? We have an online IP assessment tool where if you answer a few questions, it's not the be-all final legal advice about your intellectual property, but it gives you a sense of what things you might think about for your business, and therefore how better to and more precisely follow up on each of those things. And we can also help we have like weekend seminars for startups to help train them on the basics of intellectual property, just so that they're thinking about this. And everybody makes a very unique and personal decision about what is the right intellectual property strategy for their business in light of the competitive landscape, in light of their budget, in light of a whole bunch of factors. But it should be informed by the facts. So through our Dallas regional office, we hope to be bringing a lot more of that training and education to the South Central region of the United States. And like I said, you have an office in your home state.
Yeah, well, let's talk about the office in our home state. So we have this Texas regional office, which is in Dallas. Can you tell the audience a little bit about what your experiences are with it, what you expect from it, how it will benefit innovators and entrepreneurs in Texas and the broader region of Texas and the broader region of the United States, Southwest?
So, you know this from my background, I don't come from Washington, D.C. I come from 3,000 miles away on the opposite side of the coast, and I also come from a community that, I started with a company that was a startup that then became a big company. And what I realized is that you have to be pretty sophisticated and pretty big to know about and be aware of all the policy discussions that are being discussed in Washington or at the Patent and Trademark Office about maybe what is patent eligible subject matter and various, the Patent Trial and Appeal Board proceedings and how should the rules go. And you have to be a pretty sophisticated player. You have to have a legal department, maybe a governmental affairs department, in order to know what topics are being discussed in Washington. And so our view is that with the regional offices, everybody should be able to participate and provide input on our policies, our programs, and procedures. Because guess what? Those policies, programs, and procedures affect all innovators. Whether you're the super sophisticated company with the governmental affairs department, with the legal department who can tell you when to provide comments and chime in and provide input, or the small startup. So in our regional offices, what we are providing is, yes, the education and training on the basics of intellectual property. How do I file a patent? How do I register a trademark? How might intellectual property be used in my business? How can I determine if my invention is new? Well, you can come down to the office in Dallas and go onto the same computer system or database that our examiners have access to. And so you'll see exactly what our examiners see if you do the same search. And so a lot of training, a lot of access to databases, but also I think critically importantly is the ability for all of our users of our intellectual property system, whether you're big or small, to provide input. For example, on our enhanced patent quality initiative. We think that's a pretty important initiative, and we need everybody's input on what you like, what's working, what's not, what we can do better. And rather than monitoring the Federal Register notice, which I know not everybody reads, I know, because right, we can hopefully have video conferencing facilities out of the regional hubs, which are televised back to Washington so that all of our regional offices can provide input on these very important initiatives. Also, eventually you'll be able to go into our regional office in Dallas, and if you're an applicant and you want to have a face-to-face interview with your patent examiner, before if you wanted a face-to-face interview with your examiner, you basically had to get on a plane and fly out to Washington to have that interview. Or if you didn't want to do that and you didn't have the funds or the resources to do so, the second best alternative was having a telephone call. Or technologies are complicated and a face-to-face conversation is much better, So now eventually you'll be able to come into the Dallas regional office, and we have state-of-the-art video conferencing facilities where you can have a face-to-face conversation with your patent examiner explaining the invention, pointing to a diagram, and also eventually you'll be able to, depending upon the staffing of your case by the judges, participate in these patent trial and appeal board proceedings where you test the validity of a patent that already issued. You might be able to have it out of your regional office. And if you're a small company, that's money you're saving, and yet you're able to participate in a proceeding rather than flying you and your team of lawyers out to Washington, D.C. So it's really, as I said, at the highest level, providing a broader range of services that the USPTO offers to the local innovation community more conveniently and more cost effectively. So there's really no downside and all upside, and many cities across the country wanted a regional office in their city because it promotes innovation, it promotes economic development, and we certainly hope to fulfill that promise.
Your agency has also been involved in a number of international efforts with IP offices around the world. Could you describe a few of those key efforts and explain how they benefit entrepreneurs and inventors here in Texas?
Right, so I mentioned how increasingly global economy, right, US companies need to, and the president and the administration wants American companies to be thinking overseas, because the amount of, the amount that, the amount that we export our products and services has a direct correlation to high-paying jobs, economic prosperity at home. And so we do want a level playing field overseas. And if you go across the globe, there are some very big, attractive markets, and yet the intellectual property landscape can be friendly or less friendly, shall I say. And you can't take it for granted that all these countries share our intellectual property values. So we spend a lot of effort. We have a lot of folks come in for intellectual property training, foreign visitors. We have foreign jurists, IP enforcement officials, legislators, judges. They come into the Patent and Trademark Office and they learn about our system. And we're not saying this is the one and only one system, but you know what? The American intellectual property system has supported some of the most impressive innovation that this planet has ever seen. So if they pick up our IP values and they share them, then we think that's also good for business, because then when our companies sell their products and services overseas, they're going to encounter an environment where there's generally respect for intellectual property rights and generally remedies if intellectual property rights are misappropriated. So we do a lot of training at the PTO. I do a lot of work and I have a lot of conversations with heads of intellectual property offices across the globe. China, for example, is undergoing changes to their patent law, copyright law, trademark law, and trade secret law. And if you think about it, in intellectual property, there's nothing really else. And so for China, the intellectual property system and intellectual property rights are relatively new. I had the head of the Chinese Patent and Trademark Office come over to the PTO and we were chatting. He's like, Michelle, China has done almost everything far longer than any of you in the United States, right, by hundreds of years. However, in intellectual property, we've only been at this 20, 25 years. And so we have a long way to go. And last May I was in Beijing, and the vice premier of China asked to meet with me, and what he said is, he said, Michelle, China recognizes that it wants to be an innovation economy. And it does not want to be the low-cost manufacturer because of cheap labor and other things for other people's inventions. But in order to get there, we have to respect intellectual property rights, and we have to provide appropriate enforcement and appropriate remedies for infringement of intellectual property rights. So there's a desire, and this was the first time. In the past, they had made concessions, shall I say, because their trading partners asked them to make concessions in the area of intellectual property. I think they now realize that as a matter of self-interest, if they want to move up the value chain and be the innovator and not just the low-cost manufacturer, they need changes to their intellectual property system. So that's why I think you're seeing, changes to every form of intellectual property right in the legislation occurring underway, and the United States Patent and Trademark Office provides input on that. We have lots of conversations with them. I have a team of China attorneys working and reviewing their laws, and they also are establishing an intellectual property court system that is perhaps less subject to local provincialism. And so you've got the courts coming into place, a national court system, and you have the laws being written on the books. And I think time will tell, and we'll have to see how the application of these new laws are applied in these new courts and whether they're applied equally to all participants. But these are some pretty major changes, and that's just one country by example. So we spent a lot of time working with other counterpart offices, both in terms of sharing IP values, making sure that the laws are consistent and conducive to exporting of American products overseas. And now with more and more American companies filing in multiple countries across the globe, let me tell you, everybody's intellectual property office sprung out in its own office. They have their own rules and their own filing procedures. And we can streamline an awful lot. A lot has already been done, but there's still a lot more low-hanging fruit, so that what that means is if you're a patent counsel and you're looking to file in multiple jurisdictions, right, if our offices, which are basically examining the same patent application, shared their work product, not rubber stamping it, but sharing the work product so that the second examiner who picks it up can build upon what was already found, then that's a benefit to the applicant. And that means it will cost them less money, they will have more money to spend on more intellectual property rights or research and development. Universities too, the same thing.
We're experiencing technical to our first-generation college students. So whenever I meet a prominent lawyer like you, I always wonder briefly if you could share your personal background and how it led to your current position to be the first woman to head up this patent office. So could you share a little bit of that with us?
Sure. So I never thought I would be doing what I'm doing today. I will say, though, it is a tremendous pleasure and honor to serve in the role that I serve. My family, I guess I'm a child of an immigrant family, and my dad was an electrical engineer, and I grew up in the Silicon Valley, and all the dads on the street that I grew up on were engineers. That's just the way it was. And that's what I grew up with. So I've always grown up in an environment of innovation and entrepreneurship. And in fact, when I was a young girl, I can remember one of my earliest science projects was building a Heathkit radio, handheld radio. I don't know if you guys remember Heathkit. Maybe some of you are too young, but some of you might remember. And that's just what I did. And I didn't know that that's not what all girls did. But I actually think it was a great training. And I always wanted to be a part of the innovation economy, so I studied engineering, and I loved it. I went back to the Silicon Valley, helping support innovation, first as a programmer and engineer, and then as a legal advisor, and then in the corporate setting. And it's just really, I've been very fortunate, I've been very blessed, and it's been a remarkable experience. And I like to say, I mean, all of those experiences, both understanding how difficult invention and innovation is, all the hard work that has to go into creating something new, how fragile that can be, and then the ability to, once you have something new, to hit that market opportunity and to time it just right and to execute on your idea so that you can create and hit a market window. Those are hard issues and not to be taken for granted. And I think government and Washington, D.C., has a role to play in terms of promoting and encouraging and trying to facilitate as much of that activity as possible out of the universities, out of schools and so forth, out of corporations. And it was the ability to, and I don't think you can take the fact that, I mean, we are one of the most, we have a tremendous tradition of invention and entrepreneurship in our society, and the cost of inventing something and trying and building a company and failing in our country versus other countries, there's not that great of a stigma, and I think that's a positive thing. People are not unduly penalized for taking risks. But you can't take for granted that the system that we have now will continue in the future. And that's why I think that a lot of the policies that occur in Washington and being able to play a small part in helping to shape that, I think it's critically important because I want the system that I had growing up available to my daughter in her lifetime. And you cannot, I mean, I look around the globe, I see a lot of very competitive economies, I mean, with very strong science, technology, engineering, and math training, and a lot of drive to really also be an innovator. And in this very competitive environment, we need to make sure that we align and we have policies and programs and we're all working together to continue to promote that innovation that we have enjoyed and that I believe to be the core reason for our nation's economic prosperity.
To build off that last question, for many of the people in this audience and myself, we chose a career in academia after being in the private sector. And for you, having had a successful private sector career, what made you decide a path of government service?
Like I said, I didn't ever think I would be in my role, but I guess after a while you've done certain things in your career and you develop a certain amount of expertise and you also develop certain insights and perspectives. And I thought I could make a contribution. And I had the opportunity to give back, and it's really the desire to give back to a country that has given me and my family so much. And I'm very grateful for it. And like I said, you cannot take for granted that the system that we have now is going to be the same system that we have for subsequent generations. And if we don't all collectively try to do something about it and to push it in the right direction, we might not have the system we have today. So it was really the chance to give back, and it's a privilege.
So this will be the last question from us, from me, and then we'll open it up to the audience. So in your role as Undersecretary of Commerce for intellectual property, you advise the administration on a wide range of issues, whether it's patents and trademarks. And just this January, the agency released a report on recommendations amending the Copyright Act. Can you briefly summarize the recommendations briefly and the role that your office plays in guiding copyright policy?
So I'm not sure I can summarize the report briefly, but I'll try. It was an extensive report, but so I am the Undersecretary of Commerce for Intellectual Property, so we offer policy guidance to the administration on all forms of intellectual property, including trade secret, and there's some trade secret legislation pending, including patents, copyrights, trademarks, and so forth. And on your question about the copyright front, you all know this, right? I mean, with the invention of the internet, you can now get creative works and copyrighted works on the internet, and it's an incredible mechanism to promulgate and disseminate artistic works, music, video, literary works in a manner that is unprecedented. Before, you had to go through a publisher, and there were all these very established forms of distribution of content. And there have been so many changes in the past 15 or so years. So the United States Patent and Trademark Office, in conjunction with the Department of Commerce and the National Telecommunications Administration Agency, underwent this comprehensive study of copyright issues in the digital economy. In light of all these changes, how has copyright distribution, collection changed in this new economy? And it was trying to strike the right balance between creating the incentives to create, so that by providing exclusionary rights, so that artistic writers and creators would have the incentive to create and be able to recoup their costs, but also being able to provide the mechanisms for others to access it and modify it as appropriate. But there were a lot of wide open questions there about what is appropriate modification of something that you get off the internet. So one of the issues considered we issued a white paper, which is basically Washington, D.C. talk for a paper or report. And you basically look at all this content that's available on like YouTube and other online distribution. Can you take bits and pieces from various forms of copyrighted works and do a remix and combine it and add to it and add some stuff to it, and to what extent is that permissible or not? And it's a really complicated issue. So that was one of the issues that the report addressed. Another one is statutory damages. Right now, you can get statutory damages for copyright infringement, but it's a rather rigid by copy kind of calculation. And you can imagine in the internet space, there can be lots of downloads that can easily multiply to a big dollar damage almost inadvertently and almost with a blink of an eye. So the report analyzed the appropriateness and the calibration of statutory damages, and also the first sale doctrine. So these are a bunch of copyright concepts, but basically we put forth some legislative recommendations for changes to the Copyright Act, particularly in the area of statutory damages and what the court should look at, some factors, and giving the courts more discretion rather than sort of a very rigid kind of calculation. And then for a number of the other areas, like in the area of remixes and first sale doctrine, we recommended further analysis and a lot of stakeholder discussion and definition of best practices going forward. So we didn't recommend legislative changes across the board, but we recommended some legislative changes as well as some combination of stakeholder further research and discussion of best practices, and that's pretty much. I mean, for those of you who are interested, I can get you more information. It's literally a report. Lots of information, lots of details about copyright law, but to spare those of you who are not into copyright law, I'll stop right there.
Well, what we would like to do now is open things up for Q&A from the audience. Michael here, I think, is going to be collecting
Yes,
questions.
I've got a few questions already submitted prior to the event. So I'm going to start with this one. This one's from Charisse, who asked, at what point should you initiate seeking a patent for intellectual property? At the idea or after successes? I'm
not sure what after success means, because that could mean business success, it could be manufacturing success, it could mean, I don't know. So I wouldn't wait that long. I would say after you've got basically your conception of the invention and you think there's enough there, I would start talking to and learning about whether or not there's enough there for you to protect. I mean, it's always good to plan ahead, right? And I would encourage sooner rather than later. And oftentimes, I mean, if you're not careful and you disclose certain items through sale and otherwise, I mean, you can actually preclude yourself from being able to get rights among other places, foreign jurisdictions. And like I said, in this global economy, you don't want to be on the wrong side of it. You don't want to inadvertently preclude yourself from being able to have intellectual property protection across the globe where you think it might be advantageous to you. So you got to have enough there, obviously, but sooner is better than later. And I would encourage, you can talk to our office, you can talk to practitioners, I mean, but learn what you need to know to make an informed business decision about it.
This one's from a computer science instructor. Says, should regular courses that make videos available in those courses patent such videos?
One more time?
Yeah, should courses that make videos available as a part of the course work, should you patent or copyright those videos?
Well, I'd imagine that they're a literary work or a audiovisual work, so they're entitled to copyright protection. I'm not sure what there is to patent there.
This one asks, what are some international trends in patent protection laws? How is export control coordinated within your office?
We don't do export controls. That's another part of the government. But as far as trends in patent offices across the globe, there's a lot of talk about, again, harmonizing substantive laws so that applicants who apply across the globe are doing so in a system that is more uniform. And things like what is a piece of prior art? It kind of varies a bit from country to country, and should it not be more or less, or more uniform or less uniform? And even, for example, now I'm going into the weeds a little bit, but some patent applications in some countries are written by patent agents who are not attorneys. And therefore, is that subject to the attorney-client privilege protection? And if it's not, right, companies need to know about that because that has consequences on litigation and many other things. So we're working through a lot of these issues with many of our foreign counterparts. And I will say that other offices across the globe are also super focused on patent quality. I mean, everybody is hearing it from their stakeholders. Not to say that the agencies were not producing good quality patents, but we all realize in this day and age it's really important. There's a cost to society if a patent issues that should not have issued. Just as there's a cost to society if a patent does not issue that should have issued, just as there's a cost to society if a patent issues with claims that are more nebulous, because then litigation is spent, right, often, sometimes needlessly, trying to define the boundaries of that. So across the globe, my European patent office counterpart, Japanese patent office counterpart, we have this major priority underway. It's a pretty consistent theme across all offices, and I think it's a good thing, and we're sharing our product. I have no pride here. If another office comes up with a great idea for improving quality, we'll take it. And if we have anything to share with them, we're glad to share, because at the end of the day, the American applicant will benefit, because you need to get rights in various countries, and if you get a better, more certain right in the United States, if you get a better, more certain right in Europe or through the European Patent Office, or a better, more certain right in the Japanese Patent Office, that's good for business.
We have time maybe for one or two quick audience questions, if anyone has one. Yes, sir.
Maybe I speak loudly.
Sure.
What is the coordination between your office and the office in the U of H, which deals with patents on scientific investigation?
So the question was how your office coordinates with UH in terms of patents.
Well, I'm here for a reason today, and that is to make sure that we do things to support, right, the good work, the good research that is done at University of Houston, and I reach out to many universities across the country, right? I mean, these are drivers of innovation. Universities are drivers of innovation, so if there's anything that we can do to more tightly work with your offices and your staff. I mean, we work with corporations, we work with incubators, we work with accelerators, we work with universities, and individual inventors, right? The whole idea is, are you aware of all the services that the USPTO offers to help support and promote American innovation, to help file intellectual property and obtain intellectual property when and as you determine appropriate? So I know I was on the outside. A lot of folks are not aware of all that we offer, and we're having conversations. We will have more conversations, and that's exactly why I'm here. That's why I'm going to South by Southwest to talk to the entrepreneurs and to say, look, this is what we got. If this fits within your business model and you can use it, please reach out to us. So we're looking to support all the good work that occurs at University of Houston.
I can answer the same question from the other side. So, as Associate VP for Tech Transfer, the Office of Intellectual Property Management here at U of H reports to my position. And I think we're generally quite content with our interactions with the Patent Office. They're heavily intermediated. So in our office, we have a former patent examiner, for example, and we have a patent attorney, and we employ a very large number of outside patent counsel with diverse technical specializations. So it's a very intermediated process, but for anyone who's at U of H, we are your first point of contact, and we will essentially immediately provisional things because we're in first to file environment. So please be quick, don't wait. We'd like to hear from you too early, much more than we would like to hear from you too late.
Yeah, and actually, if I may flip the question a little bit. So we're delighted to be here to support the University of Houston, the Tech Transfer Licensing Office, and so forth. But I have an ask for all of you. And I know there are perhaps some academics and so forth and some scientists in the audience. You can help the United States Patent and Trademark Office do a better job at examining your patent applications if you volunteer through our Patent Examiner Technical Training Program. You all are at the cutting edge of research, far ahead of anybody else in whatever area you specialize in. And we have this official program where you can sign up to come in and give like an hour presentation to our examiners who examine in your technology areas. And we video conference that across our nation because we have examiners across the nation. And if they understand the state of the art and the development of the technology that they're examining in, and they're at the cutting edge of it, guess what? You're going to get a better quality patent application faster with greater customer satisfaction. And we're not discussing any particular patent application because you can't do that, right? That's saved for the office action and the formal prosecution of the application process. But even just volunteering to providing, and probably a presentation that you've given at many conferences, that you've given to your colleagues, right? Little work on your part, and eventually you'll be able to come into our regional office rather than flying out to Washington, D.C. We can videotape it and we can share it with all our examiners, and I cannot tell you how much they love getting that. They love hearing from those experts in the field. It's such a treat. I would love it too, actually, come to think of it, but it really makes a difference, and it's a real win-win. It's low cost for you all and high impact for us, and it helps us do a better job for all of you.
All right, I'll close with this quick one here. There's some talk, this one's from Maryland, she asks, there's some talk of the Copyright Office moving from the Library of Congress to the Department of Commerce. Any truth to that? What's your position on such a move?
So there's talk about that, and there have been various legislative proposals introduced in the House, and the administration, of which the United States Patent and Trademark Office is a part of, has not taken a formal position on any of the various proposals.
It's my pleasure again to thank Michelle and the USPTO for being here today. I want to thank our wonderful moderator here, Michael Haggerty, who sort of worked through some of the technical issues that we've had with our website today. For the first time in 15 years that I know, we've had our website down. So if you've had an issue turning questions in, that's the reason why. But we've sort of managed through the technical issues. I want to thank our moderators, Len and Sapna, for doing such a wonderful job. And most of all, Michelle, thank you so much for being here. We really appreciate you being here and answering these questions. Thank you.
Pleasure. Thank you so much. Thank you, Dean. Pleasure.